Morning, everybody. We are having a little technical difficulty on our side this morning, but we are over it now. We are going to be starting in about 1 minute.
Hold on, just starting. The meeting's starting.
Okay. Good.
Okay.
Okay. I'll talk to you later.
All right.
Okay, bye.
All right, bye.
How is everybody doing today? We all excited to learn about the FAR contract?
Yes.
Yes.
So I'm going to get the setup here with the screen share. Give me a second. Okay, we are ready to go on that front. So we have quite a few people participating today. I am going to get this set up, and then I am going to get chat going. Oops. Let me get the chat going here. There we go. All righty. So the way this is going to work today, I am going to go over the FAR contract. We're going to review the various terms and clauses in the contract. I am, give me 1 second to get this last bit up. Okay. We are ready to rock and roll this fine morning. So now if you have questions, you can unmute yourself and shout them out. You can type them into the chat. This is going to be a conversation as much as anything. And if you, if I say something that seems crazy, just feel free to jump in and say, Sam, what are you talking about? And we are going to get started here. Now, I am an attorney, and that means we're going to start with a disclaimer. You cannot rely on anything I say here as legal advice, although it is all going to be accurate. I'm going to dive right into the contract today. We're going to go through it step by step. I may shout out some line numbers in the contract. And if you have questions at any time, like I said, just interrupt or type them into the chat. So before I do that, though, let me just tell you, I've been doing this now 13 and a half, almost 14 years. And I sit on the committee that writes the NABOR contract, and I sit on the REAL committee, the Real Estate Industry Liaison Committee for the Florida Bar that reviews the FAR contract. So I know these forms, and if you have questions after the presentation, you can always email or call me anytime. Okay, so diving right in. First thing on the contract that you have to worry about is who is the parties and what is the property. So the contract has blanks at the very top of it that where you fill in the buyer, the seller, and the property information. Now, this would seem to be really simple and basic, but I got to tell you, this is one of the most important things that you're going to be doing as the realtor in the transaction. Now, if you have the buyer, you know the buyer, you're going to be making the offer. You can ask the buyer their name, their LLC name, their trust name, and put that information in the buyer line on the contract. But how do you know who the seller is? You have to go to the property appraiser's website in the county where the property is located and get the correct parties. And you have to look at the prior deed to make sure that you don't miss anybody that the property appraiser may have missed. If you have an LLC or a trust, make sure that you put the correct party. An LLC would be, Sam J. Saab III LLC, and then at the bottom where the party signed would be Sam J. Saab III Manager would be the signer. If you have a trust, remember to put the trustee's name. Yes, somebody have a question? Okay. So it's very important that all the correct parties sign the contract to make it binding. Now, with regard to the property itself, you need the address, the property identification number, and the short legal from the appraiser's office. You do not want to screw this up. If you put the wrong property on there, obviously we don't have a contract. There's been no meeting of the minds, and we're not going to have a closing. Now, the next part of the contract there on page 1 is the personal property. You're going to want to include the correct personal property. Now, on the FAR contract, it is always an issue because the washer and dryer are not included. But many realtors say when they do their walkthroughs that it is included, and then many buyers expect it to be included, and then many realtors buy new washer and dryer for their customer because they didn't properly include it on the FAR contract. It is included on the NABOR contract, so you don't have to worry about it there. But for those of you, and particularly in Lee County, where the FAR is more used, don't forget the washer and dryer. At least have the conversation with the customer. With regard to fixtures, note that you cannot take chandeliers. That's been an issue. A case that I had where a woman walked off with a $40,000 chandelier in Bay Colony, and we had to go retrieve that from a dock in Miami. So be very careful about what you take and what you leave. And then remember that the lender says that the personal property transfers at no value. So if you are going to transfer personal property, furniture, etc., furnishings, if you're selling it turnkey, you would want to do a separate personal property contract, and you would want your closing attorney to handle that, because if you handle it as a realtor, you're in the business of selling, you're going to subject the seller to a 6% sales tax. So it's very important that you not do personal property contracts on your own, but work with your closing attorney, your closing agent. And if you want the furniture to transfer for value and there's a loan involved, it's going to be an off HUD transaction. Okay. Before I move on, any questions about that? The property and the parties, okay? Seeing none. Let's talk about the purchase price. This is easy. This is the amount used to calculate FERPTA. This is what the top line that you're going to be negotiating. Bana is asking, is there another regular Florida contract form and the difference to FAR? Bana, yes, there's another form. They're called the CRISP form, CRISP. They're put out by the Florida Realtors. They are not blessed by the Florida Bar. And you can use those if you'd like, but they're not widely used in this area.
I can't call right now, but we'll have.
Okay, if you're going to be on the phone, please mute yourself. All right, talking about the purchase price. Get the initial deposit, in my opinion, is extremely important. Getting 5 to 10% keeps the buyer honest. And making sure that everyone has skin in the game, I think, is important. So talk to your buyers about how much they want to offer. Obviously, we're in a strong seller's market, so bigger deposits are more likely to be accepted in a competitive bidding situation. Also, make sure you put the escrow information, the escrow agent information on the contract. That's required by Florida law, the administrative code that I cite there. 61J2-1408B. And it also requires that when the deposit comes in, the title company you should request from the title company an earnest money deposit verification, and they are not required to provide it, but you are required to ask. Now, one last thing I'm going to say on this slide is the financing. On line 38 of the contract, of the main contract, the FAR contract, you need to state how much the financing is. We're going to talk later in detail about the FAR financing contingency. And let me just say up front, putting this number in correctly is so important given the case law in the area of FAR financing contingencies. It's called the LaFont case, and we're going to talk about it in great detail in a few minutes. You don't want to screw this up on the financing amount, because if you apply for the wrong loan, you lose your finance contingency. And again, I'll explain all that in a minute. So moving right along down the contract, you've got the acceptance and the effective date. So the offer must be signed and delivered. You cannot sit on a signed offer. It doesn't count until it's delivered to the other side. So in the typical situation, buyer makes the offer, seller accepts, counters, or rejects. If the seller signs the offer and accepts but does not deliver, we don't have acceptance until we have delivery, and the effective date is the last date signed or initialed and delivered. So there again, if you send your offer in at 4 o'clock on Monday, seller signs at 6 o'clock on Monday night, but the listing agent doesn't get the contract back over to the buyer's side until Tuesday, the effective date in the FAR contract is Tuesday. Now, this is different from the Majeure contract where the effective date would have been Monday in that scenario. Okay. Any questions on the offer and acceptance?
Yeah.
Yes. Okay, I thought I heard someone. Okay. Next up, let's talk about the closing date and extensions of the closing date. The closing date, unless otherwise modified by the clearance period or the Consumer Financial Protection Bureau 10-day window, the closing is on the date, and it is on the day of closing. The closing time is established by the closing agent. This gets confusing where people say, what time are we closing? When are we closing? The closing agent should tell you when you're closed or when you're going to be closed, and they control that process. Now, again, we're going to talk in greater detail. Yes, Anita, I will send slides. Thank you. Good question, Anita. I will send slides to anybody who wants them. Try to get this done in an hour, and we got a lot of slides, so I'm going a little fast. If you have other questions, again, you can always email or call me, and my contact information will be available at the end as well. I know some people get scared about speaking out in Zoom, but this contract has time of the essence for all deadlines. So the closing date cannot be missed, but it can be moved again by the clearance period or the financing, the 10-day window. It can also be changed by the force majeure clause if essential services for closing are unavailable. And we're going to talk about that at the end of this presentation. Matt is asking, what happens when the initial deposit is due on the effective date, but due to counters, etc., the effective time is after a wire can be sent? Matt, I would get a check to the title company as quickly as possible. And the reason for that is in the FAR contract, in FAR world, the time is of the essence for every deadline. So if you say that the initial deposit is due on the effective date and it's 6 o'clock on the effective date, you better bring me a check. I'll come meet you. You call me, I'll come get the check because I know how important that is. If you don't get the deposit in, you've already breached the contract, and the FAR contract says that the seller gets deposits due and owing, not just made like the Majeure contract. So it's a very important point. You need to be careful with your timing. Okay. Let's talk next about occupancy and possession. Unless leased, the seller delivers occupancy and possession at closing. So one point about this that comes up all the time, the keys transfer at closing. The money transfers at disbursement, which is after closing. So the seller gives the keys to the closing agent or to the realtor's exchange keys. And then when we have the closing and the title company announces we're closed, the buyer gets the keys. The seller gets the money immediately after. But again, if it's 6 o'clock on Friday night and we can't get a wire out until Monday, the seller can either come get a check or they can wait for their wire on Monday. But that doesn't mean that the seller doesn't owe the keys. And that gets very confusing for people, and they get very upset when they're told they have to deliver the keys into closing, but they haven't gotten their money yet. And unfortunately, that's just the way escrow works. We try to time it so that this never happens, and I can say that it rarely ever happens. Now, when you do closing and occupancy and possession, all of the personal items are to be removed, and you deliver access. That's the keys, the garage door openers, the gate codes, the key fobs, everything you've got. If there is a pre-occupancy, then risk of loss transfers at the delivery of possession, except for items that the parties have agreed to repair. And if there are leases, you have to disclose those in writing to the buyer and give them copies of leases. The buyer then has 5 days to evaluate the leases and can terminate the contract. Okay. Up next in our contract is assignability. This is section 7 on line 7980. And basically, there are 3 choices for assignability. The buyer may assign and be released. The buyer may assign the contract but not be released, or the buyer may not assign the contract. The seller can never assign the contract. That means they've sold the property to somebody else, and that would be bad. So let me just say the default law in Florida is that contracts are freely assignable. So if you don't check the box, the buyer may assign and be released. So you've got to be careful, assign but not be released. Be careful there. I want to make sure I say that correctly. If the boxes are not checked, if you skip section 7 for whatever reason, the buyer may assign the contract but may not be released. That's the default. Okay. Any questions about anything I've said before we get into financing, which is going to take a little bit and be extremely confusing? Okay, let's talk financing. So there are a number of choices for financing. You may pay cash but still get a loan. If you check the cash box on line 84 of the FAR contract, you have no protections if the loan falls through. So I always counsel buyers, be very careful on this choice. If you can't afford the property without financing, make sure you've got a long enough closing period that you can get your financing approved. On the I can't stress this next bullet point enough. Check all the boxes, fill in all the blanks on the financing contingency. If you check box B on line 88, there are a number of additional boxes and blanks that you need to fill in, and you have to pay attention to those deadlines because you can't miss them. Again, time is of the essence for every deadline. You got to apply within the 5 days if that's what it says. You've got to apply for the correct loan. Be very careful. The buyer must use diligent effort to obtain the loan, including providing all the paperwork and paying all the fees. So if you're waiting on the appraisal and you don't want to do anything else, you're going to get in trouble. Don't do that. Get all the paperwork to the lender and pay all the fees as quickly as possible. And then, of course, this is very nice in this contract. The seller and seller's agent are authorized to know what's going on with the loan approval. It says here in paragraph 8B2 on line 101, buyer shall keep seller and broker fully informed about the status of buyer's mortgage loan application, loan approval, and loan processing, and authorizes the broker, lender, and closing agent to discuss the loan with the seller and the seller's agent, the listing agent. Now, talking more about financing, the buyer must deliver the loan approval to the seller when approved. So it's not like, oh, do I tell them whether I'm approved or not? No, the contract says you deliver it. If the buyer is unable to obtain loan approval before the end of the loan approval period, then the buyer can waive the finance contingency or terminate. There's nothing in there that says that the buyer has to document their non-denial. They just have to exercise diligent effort. This is different than the Majeure contract, where the Majeure contract says that the buyer must provide a denial letter or something from the bank saying they engaged in diligent effort. That's not required by the FAR contract. Let's see here. Lynn is saying many lenders will not comply with 8.2. Yes, Lynn, you are correct. Many lenders, just out of company policy, will not discuss the loan proceeds, the loan process with the seller, but at least it's in the contract. Okay, if the buyer does not waive or terminate the contract, then the loan is deemed approved, and then the seller has up to 3 days to terminate. Why do we give the seller 3 days to terminate? Well, if you know that the buyer can't afford this property without the loan, why would you keep the property off the market and waste all your time dealing with them? Just terminate. They do get their deposit back, but it's better than the property sitting on the market for another, 30 or 40 days while the buyer works through trying to find some loan. Okay, if the loan approval is obtained, then the seller gets the deposit unless the seller defaults, which means they don't clear title, or there are property related conditions of the loan approval that have not been met, like an HOA issue, or maybe if there was a roof issue or something that had to be settled, or if the appraisal comes in low. So I got this question beforehand, and this is very important. If you are trying to wiggle out of a contract because the appraisal is low, you better have applied for the right financing, the financing stated in the contract. And that's the LaFont case that we're talking about in a minute. Property related conditions, I put some examples here. You have the option to do assumptions on line 125, but nobody really does those anymore. Or you can use seller financing, and there's the seller financing rider. If you have questions about that, let me know separately and I'll go over the seller financing with you. Personally, I love seller financing. Seller financing is great for the seller and the buyer because the buyer can deal with somebody that's easy to underwrite, and the seller gets a great deal. If the buyer defaults, they get the property back and they get all their money. So it's a win-win for everyone. Now that we've kind of gone through the financing contingency, I did prepare a little diagram for everybody. Very simple. No, really, I do have a diagram for you. Basically, you have the loan approval period where the buyer must be diligent. They have 30 days per the contract default to get their loan approval. The buyer then notifies the seller, and if they're declined, then the contract ends and the buyer gets their deposit back. If the buyer does not notify the seller has 3 days to cancel, which they can then cancel. Oops. And the contract ends and the buyer gets their deposit back. If the seller does not cancel, or the buyer notifies the seller of approval, then the contract proceeds and the buyer's deposit goes hard. Then you deal with property related conditions. If there are property related conditions and they aren't satisfied, then the contract ends and the buyer receives their deposit back. If there are not property related conditions, we go to closing. Yay, very simple. So that's kind of the financing contingency in a graph. And again, I'll share slides to anybody who wants them. You'll email me separately and I will take care of it. All right, so there is very bad, terrible case law here in Florida called the LaFont case. Give me one moment so I can fix my video. Okay, that's not what I wanted. One second, I'm just fixing the video feed. Okay, so there's very bad case law here in Florida called the LaFont case versus Florida Investment Group LLC versus LaFont. It's not good. The buyer lost her deposit because she did not apply for the loan stated in the contract. Now, the court does strain itself to give the deposit to the seller, but they said there was never loan approval as defined in the contract, which would allow the court to look at the terms of loan approval to decide whether the appraisal was insufficient to meet the terms of the loan approval. There was no loan approval because the buyer applied for the wrong type of loan. This is a pain in the rear because the loan changes all the time. So that is a difficult case, and what it basically says in the summary is, if you change the loan that you're going to apply for in the during the pendency of the contract, you need to do an amendment to contract and change the financing terms. All right, I have a question here from Paul. How do you protect the buyer's ability to get their earnest money back if the seller refuses to sign the termination? The seller believes they get to keep their earnest money. Paul, it depends on your title company or your closing agent. If it's very clear to me that the buyer is entitled to get their money back, and I review the whole case and it's obvious, then I will return the buyer's funds without a seller signed termination. But I'm going to tell you, and I'm the same as every other closing agent in this regard, if there is any question at all, I'm going to want to sign termination. If the seller simply refuses because they think they're owed the money, then we're going to court. It's going to be an intrapleader lawsuit where the title company will say to the judge, I've got this $50,000 deposit, buyer and seller are here, I've sued them both. You figure out who's owed the money, and then the money gets deposited into the registry of the court, and the buyer and seller slug it out. Okay. Any other questions on financing before I switch over and go to closing costs, fees, and charges? Anybody? You can unmute yourself. Okay, I'm going to keep going. Closing costs, fees, and charges. This is listed on the contract in section 9. This is very important to make sure that when you have the seller, you understand that your seller is committed to 4.5% of the purchase price for repairs unless you change the numbers on line 136, 138, and 140. This comes up a lot where people don't realize that they've committed their seller to a huge number on larger deals. So just be very careful there. The maximum out of pocket for the seller is what's written on those lines. And then you would escrow up to 125% of the cost of repairs to complete the repairs required by section 9 and section 12 after closing if they're not done. Remember, the seller has to maintain the property taxes maintain the property as is during the pendency of the contract. That means that the property is essentially frozen on the effective date, the date that the contract is signed and delivered, and the property stays in its as-is condition till the closing date. Wear and tear are accepted. So if you nick the wall moving out, the seller doesn't have to come in and redo the whole wall. And then, of course, the seller pays transfer taxes. The buyer pays their loan costs, association costs, and other costs associated with title, depending on who checks what box. And we're going to talk about title right now. So at least 15 days prior to closing, the title commitment is obtained and delivered to the buyer. Whoever the determining who picks and pays is by custom. And I encourage you to understand these two boxes, line 172 and 176 on your contract. If the seller picks and pays, the seller picks the title company, and that's typically in Lee County, and they pay for the lien search. If the buyer picks and pays the municipal lien search, then the buyer pays for the municipal lien search. And again, it's only by custom, and the buyer always pays for the title insurance for the lender. Okay, moving along, the survey and the warranty, home warranty. The survey, the buyer, of course, may have the property surveyed. The seller has 5 days to deliver the prior survey if they have one. And as regards to the home warranty, I've seen this come up more and more in Naples and Lee County. This home warranty, just make sure you check the box because there's no default. So if you discussed in negotiations, don't forget to check the box on line 187. Lynn has a question. Most agents in Lee County use the as-is contract and use the inspection to renegotiate or request repairs. That's exactly right, Lynn. That as-is contract says that the buyer can terminate for any reason or no reason. And we're going to talk about that a little bit further in inspections, but essentially, if the buyer doesn't like the color of the walls and they want to ask for them to be changed, they can do that. They want, you can ask for whatever you want, and it's a free negotiation in the as-is world, and the buyer can terminate at any time up to the end of the period, the inspection period, if the seller doesn't agree to his demands, and that's the way that works. Okay, special assessments. So the seller pays the full amount of liens imposed by a public body. I should bold this next bullet point. This does not include condo and HOA special assessments. Those are dealt with on the addendum A and addendum B for HOAs and condos. So again, the discussion of special assessments in 9F on line 191 relates to public body assessments. That's CDDs, other assessments. For example, Marco has a sewer assessment on a lot of the properties. For the assessment to be binding on the seller, it has to be certified, confirmed, and ratified before closing. Another difference from the Majeure contract, which says confirmed, ratified before the effective date. So now you also have a checkbox here. Either the seller can pay everything before closing, or the seller can pay and the buyer pays everything after, or the seller can pay all assessments in full. Obviously, if you have the buyer, Paul asked about the water sewer. Yes, Cape Coral water sewer falls into this category, Paul. This provision does not apply to CDDs though. So Verona Walk, Lely, what are some of the other big CDDs? I'm trying to think. They would have their own CDD addendum or disclosure that you would use. They would not. This section does not apply to them. Okay. Bana is asking, Miami-Dade County, the title charges are always paid by the buyer or negotiated. You can check the box for Miami-Dade that says buyer pays, or you can negotiate it. That is always it's always your option to negotiate it. It's always your option to negotiate it. So if you've got the buyer in Collier County and you want the seller to pay title, you grab the FARBAR contract, you check the seller title box, and you see if you can get your offer accepted. Okay. Special assessments, again, it's municipal assessments. I covered all this already. Okay, I fixed that slide. Let's talk about our disclosures. Any questions on assessments before I move on to disclosures? Okay. So the permit disclosure, the seller warrants there are no open permits or unpermitted improvements. A warranty means that the seller knows then the buyer has a claim against the seller for breach of warranty. This is worse than a breach of contract because it could be a tort claim depending on the situation. If you committed fraud or not is the situation. Lead-based paint, don't forget your lead-based paint disclosure for homes built pre-1978. I see this a lot. Please don't forget your lead-based paint disclosure. The seller must fill out a non-foreign certification or the buyer must withhold 15% of the purchase price. This is just a disclosure for the seller. So make sure that you understand if your seller is foreign or not. You want to discuss the FIRPTA implications with them prior to closing. I teach a whole class on FIRPTA. So if you want to learn more about FIRPTA, we can talk about it there. Of course, FIRPTA is the Foreign Interest in Real Property Transfer Act. So the next really important disclosure, this is on line 252. This is 10J in your contract. The seller is making a representation pursuant to the Johnson v. Davis case that there are no known latent defects which materially affect the value of the property. So that means if the seller knows about the mold and they cover it up with paint, they've broken their seller's disclosure, they violated Johnson v. Davis, and the seller's getting sued. If the seller band-aids the air conditioner and it's barely working, have they violated the Johnson v. Davis? Well, that's an open question because if you look in your contract in section 12, it simply says that the seller is obligated to make repairs necessary to bring the items into the conditions specified in the section, which is, where is the wording? I'm looking for it. Working condition, there it is on line 281. That's the one to make sure I said it correctly. So if the air conditioner is working at closing but barely, the question is, do you have a Johnson v. Davis claim? Probably not, but I would suggest that you be more than open in your disclosures to your buyers. If you're the listing agent and the seller tells you something that they have hidden, you have an affirmative obligation to disclose that to your buyer, whether the seller wants you to or not. And if you don't disclose it, you are liable for the problem. So be very careful there. It puts you in a conflict with your seller. You may have to walk away. You may have a problem. Just be very careful. And if you are aware of hidden defects, problems with the property that would not be discovered by an inspection, you have to disclose them. Usually that raises some questions. Does anybody have any questions on that? Does everybody understand that? Okay, we're going to move right along. So do you have to disclose if a person was infected with the novel coronavirus that caused COVID-19? Probably not. There are some statutes in Florida that say you don't have to disclose death or AIDS. I've not seen a case that says other diseases have to be disclosed. And the Federal Fair Housing Act prohibits inquiries into disabilities, which includes questions about medical conditions. So just don't worry about that. I would say you don't have to make a disclosure. Okay, property condition, maintenance conditions, inspections, and examinations. So this is section 12 of your contract, 11 and 12. Property maintenance is very important. The seller has to maintain the property as is as of the effective date, wear and tear accepted. This includes the lawn, the pool, and the shrubbery. So if a hurricane comes through and knocks down a couple of trees in the FAR contract, you have to put it back up. That can be very difficult. So we have to just be very careful that we know that we put a limitation in there if we think we're going into a hurricane. I'll tell you in the Majeure contract, there's a limitation to landscaping is limited to 1% of the purchase price. So that's a big difference. Okay. Generally, it's 15 days to do the inspection. That's the default. you get 3 inspections: a general, a wood destroying organism, and a permit inspection. And the seller is obligated up to the repair limit set forth in each inspection. So the general repairs must be done by a licensed professional. You can't just bring a handyman in there to rework the lighting. That's not allowed. The property needs to be free from leaks, water damage, and structural damage. And the items listed in the contract have to be in working condition, which means operating as designed to operate. Cosmetic items like torn screens, fogged windows, and missing roof tiles do not have to be fixed by the seller. The seller has 10 days to respond after receipt of the buyer's notice to correct. So the buyer has to give notice within the 15-day inspection period. Then the seller gets to respond. They can get re-inspections, and if the seller's inspector doesn't agree with the buyer's inspector, you get a third inspector chosen by the inspectors to come in and make a determination. And then if the proper notices are not given of the defective items, then either party may terminate. So similar to wood destroying organisms, a WDO is any arthropod or plant life that damages wood, but not on your fences. So if the damage is on the fence, then it doesn't count. And the seller has 10 days to have the treatment estimated and must pay up to the repair limit. If the seller already has an infestation or a treatment plan, they don't have to pay again, but the seller has to transfer warranties. And that's only, by the way, if there are no live infestations. Permit inspections, permits, bane of my existence as the closing agent. Buyers may inspect the records of the property, look for open or expired permits, and deliver notice of them. The seller then has 10 days to determine the cost to close the permits out, and up to 5 days prior to closing, the seller shall have the permits closed out. There is an opportunity for a 10-day extension of the contract, and we can note that a 10-day inspection, extension for if there are permits found, and if they're not corrected, then you can terminate. The buyer can terminate. Okay, I have a question here. How about an outbuilding? Isabel, can you be more specific? What do you mean by an outbuilding? You talking about inspections? Let's see,
yes, correct.
If there are
Termites.
if the outbuilding is on the property, then it's part of the property. It can be inspected and go through the regular process, just like the main house. Walk-through re-inspections on the day prior to or on the closing date, the buyer can do a walk-through inspection, and they confirm that all the items are out of the property has been maintained. They confirm that all treatments, maintenance contracts, and warranties are assigned to the buyer. And then the seller has to leave the property broom clean and free of debris. So let's talk real briefly about the as-is. It's basically a free look for the time period agreed to. The buyer can terminate for any reason or no reason. They can renegotiate every term of the contract. They can negotiate inspections and repairs. It's a free look. And if the buyer doesn't like what they see, they can walk away. They don't even have to tell you why. I get a lot of questions about that in the practice here. Okay, before we leave inspections and move on, do I have any questions about inspections? None? Okay. Oops. Escrow agent and the broker. So there are some protections in here. The escrow agent receives all funds subject to collection, and wires are immediately available funds. Checks are 7 to 10 business day. So you want to get your money into the escrow agent either 10 days prior to when it's due for checks, or use a wire. If you try to do a check for closing, you're going to miss your closing date by 7 to 10 days, and you're going to lose your deposit. So closing, plan for a wire. Bob, if the open permit is not closed before closing, then you, let me get that in here. Hold on, there it is. It depends if the, Bob, it depends if the amount or if the permit has been noticed and the seller has agreed to fix but doesn't get it done, then you ask for 125%. If you have not done the proper notices, then either party can terminate. Okay. So there is protections for you and your broker in here. The contract relieves the broker of some liability, but again, it specifically does not relieve the broker of their disclosure obligations under Johnson v. Davis. So again, be very careful with that. Okay, the default and dispute resolution provisions of the contract. So if the buyer defaults, the seller gets the deposits, all the deposits as liquidated damages. The seller may go through mediation and sue for damage, or they can attempt to force the buyer to close through a specific performance lawsuit. And then the deposits recovered are split between the seller and the listing agent up to the full commission. And the listing agent has to pay the cooperating agent half of what they get, or up to the commission amount. If there is a dispute, and the buyer and seller should agree to mediate their dispute prior to suing each other. And if they do sue each other, the winner of the lawsuit gets their attorney's fees paid by the loser of the lawsuit in most cases. All right, Doreen is asking, if using an as is and the buyers walk away due to inspection issues, does the seller agent have to disclose when the property is on the market if they ask the reasons why termination? No, you don't have to disclose the reason for termination, Doreen, but you do have to disclose known latent defects. So if the buyer finds the hidden mold, you have to disclose the mold, but you had to disclose anyways. All right, we're going to go through the real estate standards. This starts on page 9 of your contract, and it's the standard A is your title standard. The buyer has 5 days after receiving the title commitment to notify the seller of title defects that render the title unmarketable. So, and the seller has a 30-day cure period to fix the title defects. That can extend the closing date. If the seller can't cure the title defects in the cure period, then the buyer has 5 days to extend the contract up to another 120 days, or take title as it then is, or terminate the contract. If the seller cannot cure the defects and the buyer does not waive, then the contract terminates and the buyer gets their deposit back. So most title defects can be cured by paying money. If they can pay money, then don't worry about it. We'll get it taken care of at closing. If we need documents filed by a former spouse or somebody on trust way back in the chain, then we're going to have an issue and we're going to need to use the cure period. Okay, survey, ingress, and egress. The buyer has 5 days to deliver survey objections from the day the buyer receives the survey. Survey objections, like we just talked about, are title objections. And the seller is representing in the contract that the property has access, so make sure that the property has access, that is near a public road or private road, but with an easement. I see private road issues in Lee County all the time. So be very careful. Just because you drove up to the property, if your property is on, for say, Musketeer in Lee County, in Fort Myers, it's a private road. There's a big sign that says private road, no county maintenance. You need to make sure that you have an easement. And I'll tell you on Musketeer, there is no easement. Okay, lease information. So going down, continuing through here, now we're in title standard A, D, lease information. The seller again must deliver tenant estoppels or an affidavit of the lease terms 10 days prior to closing. Remember I said earlier that the seller had to deliver the leases to the buyer. If the leases don't match the estoppels, then the buyer can terminate and get their deposit back. Okay, timing in the contract. This is, again, title standard E. or sorry, F, timing, calendar days. So if you sign the contract on Friday and you have 3 days to get the deposit in, when is the deposit due? Anybody? When, if it's Friday, and it's a 3-day to get the deposit in using calendar days, you get the contract in on, you get the deposit in by Monday.
Monday.
That's right. Thank you. So again, think through your process. If it's Monday, then the buyer's got to be able to get the wire in time, or the check to the closing agent on time. Make sure that you confirm with the buyer that they can get to their bank or get their wire initiated on their phone, whatever it is they have to do prior to putting those times in, and give your buyer time to get their wire in. Okay, time is of the essence for all deadlines. So this is so important. You cannot miss a deadline in the FAR contract. Any deadline, not the deposit deadlines, not the closing deadlines, not the finance deadlines, not the inspection deadlines. If you do, the contract terminates, and depending on whose fault it is, we figure out the deposit. So the other thing is in this contract, and I should have mentioned this when I was talking about remedies, if the buyer defaults, neglects, or refuses to perform the buyer's obligation, including the payment of the deposits within the time specified, all the deposits are due and become the damages. So the NABOR contract says deposits made. So if you make the first deposit, then you don't make the second deposit, and you breach, buyer loses 1 deposit. In the FAR contract, the buyer is responsible for all the deposits if they breach. So again, you have to be very careful there. Okay, now let's talk about force majeure. This slide shows the text of the force majeure clause in the title standard G on page 10. There are 3 sentences in this force majeure clause. They say that performance is not required during a force majeure event. They define force majeure as a hurricane, flood, extreme weather, act of God, etc. And they say the time for performing for performance is told for the limited period during the force majeure event, which cannot exceed 30 days, or either party can terminate. Now, one of the questions that always comes up right now, and it still does a little bit even though COVID's kind of over, what do you do about COVID? Well, if it's a cash deal and the buyer can sign electronically with no notary and no witnesses, the buyer's going to have to perform even if there's COVID. If there's a mortgage and the buyer can use remote online notary, which is determined by the lender, then the buyer's going to have to perform and he's going to have to close. If the seller can't get anywhere because of COVID, and they may or may not be able to use remote online notary, depending on whether the buyer or the lender accepts the RON, the remote online notary. So I haven't seen the case yet, or I should say recently, but if the buyer can't get their certificate of approval from the association, then there's probably a force majeure and the buyer can delay. If the buyer can't move in, but they have their certificate of approval, then there probably is not a force majeure because the buyer can close, they just can't move in. If the seller can't move out, then you also have a force majeure and the seller doesn't have to perform. And I got to tell you though, the case law is generally not favorable to the impossibility of performance or frustration of purpose doctrines. I put some cases in here. Basically, you're performing in the pandemic in Florida, especially now that the governor's rules have been lifted, the governor's executive orders. There's no restrictions. All right, any questions about all that before I move on? Okay. Prorations and credits. Prorations go to the day of closing. Advanced rents and security deposits are credited to the buyer. Taxes are based on last year's millage unless this year's bill has been issued. And so when we do an estimate, there's also the rule in the contract that once the tax bill comes out, you can then re-prorate the taxes, and either the buyer or the seller may be owed money if taxes have gone up or down. Okay, a few other issues we're going to talk about here before we wrap it up. Risk of loss. Seller is responsible for up to 1.5% of the purchase price only. So if there is a casualty loss that exceeds 1.5% of the purchase price, the cost of restorations and all that are only 1.5% on the seller. Okay, I get this question all the time. Sam, I'm doing a 1031 exchange. Do I need to put additional language in my contract? No, you do not. It's already there on line 590. You don't need to add into the additional terms. Buyer, seller are doing a 1031 exchange and the other side agrees to cooperate. It's already in there. Okay, the last thing here on this slide, integration and modification. All representations that you have made as the realtor need to be in writing in the contract. If you guys have discussed that the washer and dryer stays, put it in the contract. If the TVs are staying on the TV brackets, put it in the contract. If the seller is delivering the, it's a good example, swapping the HOA, this would be like in Fiddler's Creek, you know, is paying part of the HOA for the capital contribution fee, the $18,000. Put it in the contract. Don't put it outside the contract. I see this all the time. It was in the MLS. The seller told me so. None of those things apply because there's an integration and modification clause that says that everything that is discussed is in the contract. So I'll say it the last time, put it in the contract. Okay, Anita is asking, why would a seller who is also owner of a condo in Naples prefer to request the FAR bar contract versus the neighbor? The financing contingency in the FAR bar is more seller favorable, Anita. So you can run into the situation where a seller wants the person locked in and doesn't want them fishing for financing, and the neighbor contract more so than the FAR bar allows that. Okay. Any questions? That is the end of our presentation. Does anybody have any questions on the FAR bar contract? You can also ask questions on the addendums. I just went through the main contract and the as-is contract, but I can also, there are, 28, I believe, addendums. Michael is asking, can you use on or before for the date? Michael, you cannot use on or before for the date. People do this all the time. It makes people feel comfortable. Yes, we'll close as soon as we're ready. We're going to put on or before March 1st in the contract. Well, the closing date is March 1st, unless the buyer and the seller have agreed to a different date. And so if you shouldn't just write on or before the date. If the buyer wants the option to close early or the seller wants the option to close early, it should be written into the contract in such a way that the buyer at their option can close early. And so you want to be very careful about how you write that on or before. I see it all the time and it means nothing, basically. Okay, Bob is asking, if buyer uses FAR bar contract in Naples, can the seller require the neighbor contract? The seller can require whatever they want, and it's a seller's market, Bob. So if you are more comfortable with the neighbor form and you don't want to deal with the FAR bar, you can certainly tell any buyer, hey, we're only taking offers on the neighbor contract. Make sure though that you get that in writing from your client, from your customer, because you don't want to be in a situation where they the seller would take a FAR bar offer and you were just more comfortable. Make sure you always talk about it. Bania, you're asking what contract is best in my knowledge. Each contract is a tool. Sometimes you want the neighbor because it has a different financing contingency that's probably more buyer favorable, but the inspections are tougher for the buyer. Sometimes you want the FAR bar as is because you like the finance, you're the seller and you like the financing contingency and you want an as is contract. I would say there's very little reason in Naples to use the FAR bar contract, and there's very little reason in Lee County to use the neighbor contract. Depending, but again, it depends on the inspections and the finance contingencies that you want to deal with. And of course, they're all modifiable. Just get your attorney to do it for you. Bob is asking, can a seller reject any and all offers, even if they're full price with no contingencies? Absolutely, Bob. There's no court that's going to force a seller to sell if they haven't signed the contract yet. I haven't seen that case. So it just depends on where you are in the process. If there's been an acceptance and then the seller is trying to back out, that's a different story. Okay, and you can unmute yourself if you have a question. I'm not sure. I don't think you need my permission. Yeah, you can unmute yourself. So if you have questions, shout them out. Otherwise, I'll give you one more minute here. Otherwise, we're going to wrap it up. Okay, if you want the slides, email me. Oh, my email. I'll put my email in the chat right now. All right, one more question. If the seller does not accept the full price listing, is the commission still due to the listing broker? Anita, it may very well still be due, yes. The seller may be obligated if you bring a full price, no contingency offer that's on the listing agreement and the seller refuses, you may still get your commission. All right, my email is sam@sodlegal.com. It's in the chat. If you want the slides, shoot me an email or text me. I'll put my cell phone number in here. Text, call, whatever you need, let me know. I will send out the slides. Thank you all for participating today. I really appreciate your time. And I will be around for questions. Whatever you need me, just shout it out. Talk to you all soon. Thank you.
Thank you, Sam.